A federal high court in Abuja has frozen the bank accounts of 32 individuals and companies linked to the End Bad Governance protests pending investigation and prosecution. Justice Emeka Nwite ruled on an ex parte motion filed by Ibrahim Mohammed, counsel for the Inspector General of Police. The ruling, dated August 20 and made public on Sunday, ordered the banks to freeze the accounts and apprehend any persons transacting with them. The accounts allegedly involve proceeds from unlawful activities, including criminal conspiracy, terrorism, financing, treason, cyberbullying, and cyberstalking. Earlier, President Voice of the Masses and Support for Credible Leaders Ibrahim Oluwatobiloba shared his thoughts on this on the news.
For me, the action of this current government is a reminiscence of military era. One would not think that this government will precipitate doing such a thing. The government should understand clearly that the hunger he has unleashed on Nigerians, and after doing that, he expects Nigerians to keep quiet. He never thought Nigerians would react, and Nigerians have reacted by exercising their constitutional duty of protesting, which they did peacefully. But I'm surprised that government will now embark on freezing their account. But as far as I'm concerned, that will still not deter the Nigerians from still embarking on more protests to ventilate their angers. For me, court orders cannot stop somebody from exercising his constitutional guaranteed freedom of expression, right to protest. As far as I'm concerned, all the activities of government so far has angered Nigerians the more, and they will be coming out harder to protest in whichever way they can do that.
Now, to discuss this, we are joined by legal practitioner Valerian Nwadike. Valerian, good evening. Thank you for joining us. Big question, what are your thoughts on the freezing of the bank accounts of 32 individuals and companies linked to the End Bad Governance protests?
Good evening. Thank you for having me. I want to make something really clear. As awkward as it may sound, what the court did is not unconstitutional, to be honest. They were so empowered to do so. If we are putting in cognizance the case of Dangaba against FRN, 2014, 12 Nigerian Weekly Law Reports, Part 1422. The Court of Appeal resolved that question whether an ex parte order freezing an account of a defendant by EFCC was unconstitutional. The Court of Appeal said it is not unconstitutional, that in fact, Section 44(2) of the Constitution of the Federal Republic of Nigeria as amended permits temporary taking of possession of property for the purpose of any examination or investigation or inquiry. So what the court did is to place a post-no debit on the account, meaning money can still flow into the account, but the account will be temporarily frozen pending the conclusion of investigation by the police. Being an ex parte order or an ex parte application, it is an order that's going by the Court of Appeal rule should last, I think, 14 days, subject to renewal. So talking about the legality or otherwise of it, I don't think anything the court did was illegal. However, the defendants also have their own remedy because the law says where there is a wrong, there is a remedy. The people their accounts were frozen also have the right to approach the courts to enforce their fundamental rights to either vacate the order or to enforce their right to have access to their accounts.
All right, thank you, Valerian. But how might this court order affect future protests and the exercise of civil liberties in Nigeria, for instance? Could it deter individuals from participating in similar demonstrations in the future?
I don't think so, to be honest. I sincerely don't think so. So far, the persons, their accounts were frozen, can, know fully well that they didn't do whatever they are being accused of doing, because by the virtue of our laws, an accused is presumed to be innocent until otherwise proven. So as far as I'm concerned, they are innocent until the court says otherwise. So what the court is doing is freezing the account, which the law enforcement is suspecting that that account might has been used to finance terrorism. So it doesn't mean that they are terrorist sponsors or terrorist financiers. No, the court have not said so. So as far as I'm concerned, so far, people carry on their activity within the ambit of the law. There's nothing to be afraid of, to be honest. The onus is on him who alleges to prove. So the inspector of the police who instead the action should prove beyond reasonable doubt that these guys are financing terrorism, which I believe is left for them to prove.
So, Mr. Nwadike, what level of transparency and perhaps accountability is being demonstrated by the government in this case? Are the charges and evidence being made public? How can the public ensure that the investigation and prosecution are conducted fairly and also impartially?
I cannot speak on behalf of the government because the government have not been showing, the government has been totally biased from the onset before the protest. I mean, the government has already been saying that the court protest is going to be violent and all whatnot. I mean, my learned senior Tony Falana stated clearly that if the government is always talking about violence, that means the government wants to sponsor violence. You know? So, but what I'm trying to say, in essence, is that I cannot speak as regards the transparency of the government, but I can state categorically that the persons whose account has been frozen can approach the court. The court is not an emotional place. Emotion doesn't play any role in the court. The persons involved should get their lawyers and head to court to challenge the order, either to vacate it or to enforce their fundamental rights. Court is a public space. Everybody has the right to, appear in court.
Well, thank you very much, Mr. Nwadike. Thank you for joining us this evening.
Thank you. God bless you.